This lecture will be devoted to prenatal diagnostic techniques, regulation and prevention of misuse Act 1994. So, basically, we would like to discuss what exactly prenatal sex determination means and the another important concept, that is female feticide. So, the very introduction relating to the Act is that it provides for regulation of the use of prenatal diagnostic techniques for the purpose of detecting genetic or metabolic disorders or chromosomal abnormalities or certain congenital malformations or sex-linked disorders, and for the prevention of the misuse of such techniques for the purpose of prenatal sex determination leading to female feticide, and for matters connected therewith or incidental thereto. So the very Act provides for prohibition for the misuse of prenatal diagnostic techniques for determination of sex of fetus, leading to female feticide, prohibition of advertisement of prenatal diagnostic techniques for detection of determination of sex, permission and regulation for the use of prenatal diagnostic for the purpose of detection of specific genetic abnormalities or disorders. It also provides punishment for violation of the provisions of the Act. So, in consequence to these aims and objectives of the prenatal diagnostic techniques, regulation and prevention of misuse Act 1994 was subsequently amended in 2003 and renamed as Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Determination Act 2003. So now we would like to discuss exactly, after analyzing the objective, what is the provisions of Section 3, it relating to genetic counseling centers, genetic laboratories and genetic clinics. So the very Section 3 provides for regulation of genetic counseling centers, genetic laboratories and genetic clinics, and while Section 4 provides relating to regulation of the techniques. So regarding that, it provides for regulation of prenatal diagnostic techniques, and as well Section 5 of the Act provides that for written consent of that particular pregnant woman. So it requires written consent of pregnant woman and prohibition of communication of the sex of the fetus. And Section 6 prohibits determination of sex, and it prohibits sex determination, and while Section 7 provides for constitution of Central Supervisory Board, and as while Section 17 of the Act provides regarding advisory committee. So it provides for appropriate authority and advisory committee to be established by the concerned authorities, and while Section 18 of the Act provides for registration provisions, and in particular it requires registration of genetic counseling centers and genetic laboratories or genetic clinics. And while Section 22 of the Act provides prohibition of advertisements. It prohibits advertisement relating to prenatal determination of sex and provides for punishment for contravention, and that particularly regarding the very punishment is up to 3 years and the fine is up to rupees 10,000, and as well Section 323 deals with offence and penalties committed under the Act. So it provides for such offences and penalties that any medical genetist or gynecologist, registered medical practitioner, or any person who owns a genetic counseling center, a genetic laboratory, or a genetic clinic and renders these professional or technical services, whether on an honorary basis or otherwise, and who contravenes any of the provisions of this Act or rules made thereunder, shall be punishable with imprisonment which may extend to 3 years, and with fine extending to 10,000 rupees, and on any subsequent conviction with imprisonment which may extend to 5 years, and fine extending to 50,000 rupees. The very name of such medical practitioners may be removed from the register of the Medical Council of India for a period of 2 years for the first offence and permanently for the subsequent offences. Any person who seeks the aid of such genetic center, laboratory, or medical practitioner for determination of sex of fetus of any pregnant woman shall be punishable with imprisonment up to 3 years, and with fine extending to 10,000 rupees, and for subsequent offence with imprisonment up to 5 years, and with fine up to 50,000. And as per the provisions under Section 24 relating to the very matter, presumption by court, so presumption in the case of conduct of prenatal diagnostic techniques may be drawn by court unless the contrary is proved, that the pregnant woman has been compelled by her husband or the relative to undergo prenatal diagnostic techniques, and such person shall be liable for to undergo prenatal diagnostic and abatement of offence under Section 23 subsection 3, and shall be punishable accordingly. And as per the provisions of Section 25, which relates to penalty for contravention, so it provides penalty for contravention of the provisions of the Act or rules for which no specific punishment is provided. And as per Section 26 of the Act, which relates to offences committed by companies, so Section 27 provides that these offences committed under the Act are cognizable and non-bailable and non-compoundable. So, the very offences are considered as cognizable committed under the Pre-Natal Diagnostic Techniques Regulation and Prevention of Misuse Act 1994, and as it is subsequently amended in 2003 and named as Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Determination Act of 2003. So, the offences committed under this provision provided under Section 27 are cognizable, non-bailable, and non-compoundable. And as per the provisions of Section 28, the complaint by and to the appropriate authority. So it provides that The complaint under the Act may be made by appropriate authority or a person who has given notice of not less than 30 days to the appropriate authority of his intention to make a complaint. And as while Section 29 provides for maintenance of records by all such genetic council centers, genetic laboratories or genetic clinics. So it requires for maintenance of records, and those records to be maintained by genetic council centers or genetic laboratories or genetic clinics. And now we will discuss regarding the very power given for search and seizure under Section 30 of the Act. So Section 30 provides the power to search and seizure of records, etc., as it is provided. And now we would like to discuss those amendments and insertions made under the 2003 amendment, which renamed the 1994 Act as Preconception and Pre-Natal Diagnostic Techniques, Prohibition of Sex Determination Act 2003. So, the very Act as amended, it provides the main purpose is to improve the regulation of the technology used in sex selection. So, the very amendments in 2003 provides that amendment of the Act mainly covered bringing the technique of preconception, sex selection within the ambit of the Act of 1994 and bringing ultrasound within its ambit, so also empowering the Central Supervisory Board, Constitution of State-level Supervisory Board, and also provisions for more stringent punishments, and also empowering appropriate authorities with the power of civil court for such seizure and sealing the machines and equipments of the violators of the provisions of the Act. As such, also regulating the sale of ultrasound machines only to registered bodies, and these are the very important insertions are made under the Act to Prohibition of Sex Determination as provided under the amendment made to the original Act, that is Pre-Natal Diagnostic Techniques Regulation and Prevention of Misuse Act 1994, and in particular in 2003 it was rudely amended and renamed as Preconception and Pre-Natal Diagnostic Techniques and Prohibition of Sex Determination Act of 2003. So, in that connection, we would like to discuss the very important landmark cases and judgments relating to the provisions of the Act, and in that connection, first, we would like to discuss the very important leading case, and that is Union of India versus Binod Soni and others, which was decided in 2005. So, in particularly, this leading case relates to the petitioners in this case were a married couple They had essentially raised two arguments against the Act's constitutionality. First, that it violates Article 14 of the Indian Constitution, and the second argument that it violates Article 21 of the Constitution. However, the Article 14 challenge was not pushed into submission at the time of the hearing. However, the Honorable High Court pointed out the flaw in this justification by stating that the right to life and personal liberty cannot be stretched in any way to include the freedom to forbid the conception of a female or male fetus, which should be left to the will of nature. The High Court held that these rights, even if further expanded to the extremes of the possible elasticity of the provisions of Article 21, cannot include the right to selection of sex, whether preconception or post-conception, citing Supreme Court decisions that explain that Article 21 includes the right to food, clothing, a decent environment, and even protection of cultural heritage. The High Court noted that this Act is factually enacted to advance the child's right to complete development as provided for under Article 21 of the Constitution. Therefore, regardless of the infant's sex, a conceived child has a right to full development under Article 21. As a result, the High Court rejected the petition, ruling that there was no evidence at all that Article 21 of the Constitution was violated under the provisions of the Act. And now we will discuss another landmark judgment, which is Sumoto taken by the court, Sumoto versus State of Gujarat in 2008, and in particularly the following issues were raised in this case for consideration. The Section 28 of the Preconception and Pre-Natal Diagnostic Techniques Prohibition of Sex Selection Act permit a court to find a violation of the Act upon receipt of a complaint from any official authorized by the appropriate authorities to file such complaint. Thus, the provision to subsection 3 of section 4 of the Act mandate that the complaint should include specific claims about the violation of section 5 and section 6 of the Act. Also, the question raised, is it the authorities' responsibility to establish that there was a contravention of the provisions of section 5 and 6 of the Act, and the very judgment delivered in this case, as it was expressed by their lordship, a court may take notice of an offence under the Preconception and Pre-Natal Diagnostic Techniques Prohibition of Sex Selection Act 1994 on a complaint submitted by any official authorized in that regard by the relevant authorities according to Section 28 of the Act. The provision of Section 4, subsection 3 of the Act does not mandate that the complaint alleging accuracy or inadequacy In preserving records in the required way should also contain an accusation of violating Section 5 or 6 of the Act. The burden of proving a violation of Section 5 and 6 does not fall on the prosecution in a case based on allegations of a shortcoming or error in maintaining the record in the manner specified under subsection 3 of Section 4 of the Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Determination Act 2003. So now we would like to conclude our lecture on the very important topic, that is the Pre-Natal Diagnostic Techniques Regulation and Prevention of Misuse Act 1994, subsequently amended as renamed and amended as Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Determination Act 2003. So, the very label of the Act acknowledges fell short of expectations. Women's attitude toward the sex of children and social factors that favor male offspring are still ingrained in society. It is imperative that the media, social workers, and medical personnel take an active role in educating the public and changing women's attitude. The most prevalent tools of preconception and prenatal diagnostic procedures act as to monitor female feticide and prevent it from occurring after being put into effect. Its effectiveness is clear. A good indicator of the Act sex ratio has risen to 118. So, every 100 female or 947 females for every 1000 males, and is increasing at an estimated annual rate of 0.19%. Although there is still a lack of knowledge of the crime of female feticide in rural India, the government has introduced several programs to combat it and promote the welfare of girls in order for people in rural area to stop these activities. So, at last it can be seen that the medical health law regarding protecting the female fetus has resulted in some changes, but the medical fraternity needs to be protected at the same time from these minor offences. For this reason, the right to operate a clinic, hospital, or nursing home with all of these regulations that are in harmony with the responsibilities of doctors. Medical ethics needs to be properly examined, as doctors who have a constitutional duty to treat the sick and injured. So, this is all about the Pre-Natal Diagnostic Techniques Regulation and Prevention of Misuse Act 1994. So, in particular, we have discussed the very objectives relating to prenatal sex determination, and in particularly female feticide, and also the amendment of 2003, which renamed the very act as Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Determination Act of 2003, and in dealing with all about the provisions of the Act in particularly, we have focused on genetic counseling centers, genetic laboratories, and genetic clinics, and and they very particularly dealing with their registration provisions and the very regulation of the techniques. And also we have discussed the very provisions relating to the prior written consent of such pregnant women. And finally, under Section 7, Section 6, how it is prohibits sex determination and for the establishment of Central Supervisory Board and State Supervisory Board as per the provisions under Section 7 and Section 17 for Advisory Committee. And also we have discussed regarding prohibition of any kind of advertisement as per the provisions under Section 22 relating to prohibition of sex determination. And also we have discussed the various offences and penalties falling under the Act as per the provisions of Section 23 and also of Section 25 and offences committed by the companies under Section 26, and finally how Section 27 provides that all offences committed under the Act are cognizable, non-bailable and non-compoundable. So also the very power of search and seizure. And in that connection we have discussed two important landmark judgments. One is Union of India versus Binaksoni and others, decided in 2005, and another judgment relating to the state of Gujarat, decided in 2008, taken over so much by the court. So finally also we have discussed in brief about the conclusion relating to the Act Pre-Natal Diagnostic Techniques Regulation and Prevention of Misuse Act 1994, which was amended in 2003 and renamed as Preconception and Prenatal Diagnostic Techniques Prohibition of Sex Determination Act.